Hi, I'm Launi with Learn Law for All, and today we have Daniel Riley with us. Hi, Daniel.
Hi, how are you?
I'm great, thank you. Thank you so much for being here. I'm excited to talk about this. Today we're talking about objections and different kinds of objections, why we need them. Dan is great on this. I think one of the things that makes him so great on this is that he does appeals, and so he knows why they're so important. So Daniel is a board certified family law specialist and a certified quadro professional, which is a really unique combination. I don't know, is there anyone else that has that kind of
I,
background, Dan, that you're
I'm
aware
I'm
of?
not aware of anyone else that has a dual certification.
Because in Arizona, you can only be specialized in one area of law. And then this certified quadro professional, that's a national thing, right?
Right. So yeah, the Quadro certification is through a national organization, and family law specialization is through the state bar where I practice, which is Arizona.
Okay, and I'm going to ask you to speak up just a little bit more.
I'll scoot a little closer and
It's
I'll try to project
Thank you.
more.
So his primary practice involves the valuation and division of retirement assets, and he practices in all areas of family law and appeals. So he kind of knows all of it, which I love. I think it's so unique, especially in objections, because objections are so important. And can you tell the listeners? Oh wait, real quick, I do want to do my disclaimer that just because you're listening to this podcast does not create an attorney-client relationship. Our podcast is meant for entertainment and educational purposes only, and not meant to give specific advice to anyone. I am only licensed in Arizona. Dan is licensed in Arizona, but although his quadro information is national, so you can always hit him up to talk to him about the quadro practice, because that's a different sort of area. But so I really wanted to talk to our listeners about what an objection is and what it's for.
An objection is a request to keep out testimony or evidence. And there can be really good reasons to do that. If the evidence is improper for some reason, or if the testimony is unclear, an objection can be a very useful way to help not only yourself, but to help the judge have a better understanding of what's going on.
And so why is it important? What happens if you don't object where you should?
The list of possible problems when you don't object when you should is very long. A trial it's a story. It's your opportunity to tell your story. The other side wants to tell their story, and if they are admitting evidence that really is improper and shouldn't be coming in, but you're letting it slide, then they're telling a story that is shaped by information that may be improper. And then because I do obviously a fair amount of appeals, there could be issues on appeal where that evidence should not have come in. But if you did not object, you will not be allowed to argue that on appeal. So you have to object. It's called preserving the record for appeal. And then if the judge rules in a way that the Court of Appeals determines was incorrect, you've got an argument on appeal.
Now, I know that, okay, so I want to just sort of differentiate too. Like in depositions, your objections are form and foundation. So we're not really going to talk about depositions specifically, because those are just to preserve the record, right? So we're really talking more about the litigation aspect of it. And so I did want to talk to you about your thoughts on foundation, and I know we talked about this a little bit in the CLE, so we did a CLE on this. And you've had the same history that I've had for foundation. One, as a new lawyer, it's sometimes embarrassingly difficult to get a piece of evidence in when you have a very experienced opposing counsel who just keeps saying objection, foundation, objection, foundation. And you're like, how do I get that in? So can you give us a little bit of background on how to get that in?
Yeah, so and I'll share a possibly embarrassing story. So where I practice, in your third year of law school, you're actually allowed to go to trial and argue cases, as long as you have a supervising attorney. We call it Rule 38 certification. So in my third year of law school, I had my very first trial. I thought I was so prepared for it. And almost immediately, opposing counsel starts objecting to foundation as I'm asking questions, probably 5, 6 foundation objections in a row. And to my supervising attorney's credit, she just let it go. I mean, I'm sitting there thinking to myself, please help me. I don't know what I'm doing, but she just let me suffer. And looking back, I'm glad that she did, because she let it go on about 5 or 6 questions in a row. And then she said, foundation is the who, what, when, where, why. You have to explain to the court who this witness is, where they were, when it happened, and how they know what they know before you can start to ask them what they actually know. And it was such a mortifying experience that I have never screwed up foundation since then, because I just thought, I never want to feel this way again. This is awful.
And
So,
that's not unusual at all. I mean, you know this. It's not unusual, especially for new attorneys or even pro se litigants, to just have such a difficult time setting foundation that oftentimes they give up. I mean, that can be a big problem. They just give up on the evidence and it never gets in there. They're just like, oh, well, we'll just skip that. I mean,
yeah.
how many times have you heard that?
In the last couple months alone,
Right.
3 or 4 times. Yeah,
right.
It's foundation is a deceptively complex issue. The way I explain it when I'm teaching other attorneys is, don't get involved in toddler story time, because we have all had the experience of either we have kids of our own or we have watched other people's kids, and toddlers tell stories in a very toddler way, which is, and then Timmy pushed me down because he wanted the green one, but I had the green one. And then she came over and said, you guys stop being jerks. Well, you have no idea who Timmy is, the green what, who is this unnamed she, that you have no idea what's happening. And that's because it's a lack of foundation. So foundation is, who is this witness? Where were they when this thing happened that they're going to talk about? When did this thing happen? And how is it that they could see it and could observe it and know about it? And that's when you can then ask them, what did you see? So foundation is the who, what, when, where, why. You just got to get that out of the way so that the judge understands who this person is and how they know what they're about to talk about.
And you have to do that with not just testimony, but also documents, right? I mean, how do you do that if there's a document? What do you ask your clients about it?
It's a really related concept. So foundation and authenticity are interrelated concepts. So a document, it's the same idea. You who authored the document, when was it authored, what was the context in which it was authored, where was this prepared, and then once you've got that out of the way, okay, what is it? Let's now talk about the actual contents of this document. So foundation and authenticity, very similar. It's just the who, what, when, where, why.
And then when you're providing some document that's there, you could run into the hearsay issue, right?
Yes. So yeah, hearsay is probably more infamous for the litany of exceptions than the actual rule itself. So hearsay is really just any statement made out of court by a human being that is offered to prove the truth of the matter asserted. So, and it can be testimony, it can be documents. So an email that you want to present as an exhibit is always going to be hearsay, because the person didn't sit there and write that email while they were on the witness stand. It's an out-of-court statement. So that's the general rule of hearsay, but then you have numerous exceptions to when hearsay is going to be allowed into evidence.
So we also talked about, we had kind of an interesting conversation in our CLE, which was the relevance objection, because one of the things, and family law really more than probably, I mean, it still could be other areas for like personal injury and stuff too. Um, but our clients like to tell stories sometimes, right? And so sometimes they just like to ramble on and on about what's going on. So can you kind of talk about why something has to be relevant and what that objection is?
Yeah, so the concept of relevance is going to depend on what the issues are in the case. So, for example, if you've got children and child custody is going to be at issue, our child custody statute says the court has to consider whether substance abuse is present. But if there are no children, and this is just a divorce where we're dividing up property, that same exact evidence is no longer relevant because it's not relevant to the value of any of the property. It's not relevant. We're a no fault divorce state. So if that was the one of the reasons for the divorce, that doesn't matter because from the court's perspective, we don't consider the reason for the divorce. So just because something might be relevant in one context doesn't mean it's going to be relevant in every context. Did that make sense? The way I explained that?
I mean, that absolutely makes sense. And I know other states do have, they require fault for divorce. I just did a one in Georgia, I think it was, and we were talking about what has to be pled in their pleadings to make sure that they, pass the muster to get the divorce going. That there has to be some kinds of allegations, which is very interesting in this day and age. Typically it's just like, I want out, and you get to be out. Another thing that we talked about, and we didn't get to talk too much about it, but we did get to talk a little bit about it, was motions in limine. And I think this is, you and I talked about that. You said you thought it was very underused. I agree. I rarely did it too. But when you have such a limited time period to present your case, you might want to do a motion in limine. So can you talk about that a little bit? What it is, how to do it, when to do it?
Yeah. So in trial is not your only opportunity to present objections or to try to obtain the admission of evidence. If you've got a really critical piece of evidence and you expect the other side is going to object to it, or if you're on the other side, if they have some critical piece of evidence, but you think there's a problem with getting it into the record, you can file what's called a motion in limine, which is a request that the judge rule on the admissibility of that evidence before trial, so that you're not taking up trial time and having to argue the admissibility on the fly. You can take your time and make a well-reasoned written argument as to why this piece of evidence either should be admitted or should be kept out. And especially family court. I mean, we get, where Launi and I practice, we get such little time for trial. If you're spending 10 minutes arguing over the admissibility of a piece of evidence, that's 10 minutes that you could have presented testimony, you could have presented an oral argument at the conclusion of the case. So 10 minutes can be critical in a family law case. If you can resolve that admissibility question before trial, a motion in limine is a perfect and underutilized tool for doing that.
So let me ask you this, because it just came to mind when we were talking about, because I've had this happen. I mean, I think you need to do the motion in limine enough, far enough before the trial that the judge will take it under advisement and come up with a response, or, let you have a hearing. Now, when you when you file a motion in limine, do you request a hearing?
I don't. I've never requested a hearing on a motion in limine. But usually when I've filed motions in limine, it's about things like therapists' records, medical records, where I don't really think the court needs to have a hearing on those. It's the written motion alone presents my argument fully.
Because I think a problem that we could run into, at least with our judges here, I know they're very backed up and they have a lot, like their calendars are packed. So when you file it and they say, well, we're going to hear it at trial. Now you've just wasted, the time. You don't want to do that to a client, but I mean, I still think it puts your argument out there, makes the judge aware, but then you just do the housekeeping, before your trial, and then you're still spending that time doing it. However, I guess if you do it on a housekeeping way, then you're sort of dividing the time, as opposed to if you try and present the evidence and then there's objection and then there's a long argument about it that takes 5 minutes. You're wasting only your time as opposed to the community time or the judge's extra time. So like in Arizona, they take, we get 3.5 hours of trial time for a whole family case. And so each party is going to get like an hour and a half, and the judge is going to take a half an hour at least, typically something like that. And so that could come off like the judge's time or the court's time, right? As opposed to if there's an objection while you're trying to admit the evidence, then that's going to come off of your specific time. So I guess it's still probably worth it to keep those 5 minutes.
I think so. Yeah.
Yeah. I think that would still be worth it. So, I mean, do you have any other tips about objections?
Don't be shy about objecting. It's normal. It's people who aren't familiar with court, they walk into court thinking it's like real life, and it's not. Normally it would be exceptionally rude to interrupt another person in real life. In the courtroom, it's expected that you're going to interrupt and say objection. There's nothing rude about it. Don't feel bad. It's a normal part of the process. So that would be my closing advice: is object if you think there's an objection. Don't hold your fire.
Yeah, and one bit of advice I would like to add is, when I was new to practicing, I always took a list of objections, and I had them there ready so that I could just look down, because you can say, Your Honor, objection, and they're going to say for what? And now you're going to have to come up with a name. And unlike what you see on TV with these long speaking objections, well, he just said that, she just said that, and that can't come in. And, the judge will say, well, you can't, give me an objectable reason, right? And so I always took a list. So I'll attach a list to this and to the CLE that we did, because I do think that that's important, to make sure that you know which objection to use, so that so that you get it. And then my other one was that when I know something's going to be objected to, which I often do, because oftentimes I'll lead, or oftentimes, I don't have the foundation that I need. There's times where something's going to be objected to, and you've got to have a good argument. So even when I write my questions and I know this question is going to be objected to, then I write my response on it, because in trial you can get flustered. Yeah. And you're on a time crunch. And so if you just already have that thought out, I think that's helpful.
And there are some things are always going to be objected to. If you've got a police report and you don't have the police officer who wrote the report there to testify, you're going to get an objection. So be prepared to say, this should be admitted anyway because it falls under this exception to hearsay. So yeah, definitely anticipate, write a sticky note, whatever you have to do, so that you're not trying to think of that exception on the fly. You've already thought ahead about, okay, I'm probably going to get an objection on that. How am I going to respond to this?
Yeah, I think preparing is so important, and just anticipating those things, because when you're in there and if somebody's hammering you, especially if you have a really aggressive opposing counsel, where you're almost just afraid, that everything coming out is going to be objectionable, first of all, try and steer yourself away from that and try and do, short, simple statements, which Dan did talk about in our CLE. So take a look at that. If you can do it without getting objections, great. I just feel like there's always things. I just know when I do it, there's going to be objections, and possibly, by the way, for leading especially too, but when you're on a time crunch, sometimes the court will let you do that anyway, right? Sometimes the court will let you lead. That's not necessarily the best evidence. That's not what they like the best. But if you need to get some sort of down and dirty information in quick, that's the way to do it. Well, thank you so much, Dan. I appreciate you being here. I appreciate you doing the CLE, and always enjoy having you here.
It was a pleasure. Always enjoy chatting with you, Launi.
Thank you so much. Bye-bye.
Have a nice day.